Hi, my name's Chris Cruz. Many of you know me as Coach Cruz. I currently work as a probation officer in Sulphur Springs in Delta County. I grew up in Ladonia, Texas, and graduated from Fannondale High School. Attended Paris Junior College, the old East Texas State University, and Texas A&M University Commerce. I have a bachelor's degree in history and a master's degree in educational administration. I worked for almost 30 years as a special education and history teacher, and I worked at Campbell, Fannondale, Cooper, Greenville, and then back at Cooper, and that's where I retired. I coached most every sport one time or another, but I was mainly known as a football and track coach. Upon my retirement, I went to work for the 392nd and the 439th Judicial Districts in Rockwall as an adult probation officer. Recently, I accepted a position at the 8th Judicial District in our area so I could come back home and try to help people in the area that I live in. Today, I'm going to talk to you about some of the requirements to be a probation officer and some of the ins and outs of probation, duties that the probation officer may have to deal with on a day-to-day basis, some of the more difficult things and some of the good things. To become a probation officer in Texas, anyone can do this as long as they have a bachelor's degree from an accredited university. The requirements are outlined by the Texas Department of Criminal Justice. For instance, no one that volunteers or works employed as a peace officer can qualify to be a probation officer. In addition, no one under the community service or parole or currently serving a court sentence can qualify for employment. The recommended degree for being a probation officer in Texas is something to do with criminology or a related field. It's to be noted that any bachelor's degree, though, as earlier mentioned, from university or college will count. It looks better, though, if it's criminology or a related field and you've gone through some training, with a probation office. I'll talk briefly about some of the certifications that a person will be required to get to be a probation officer. One of them is optional. It depends on the judicial district that you work in. Probation officers are required to become certified within a year of accepting their first job. They will be required to attend a week-long class in order to prepare for the certification exam. The governing body for Texas Probation is CJAD. It's short for Criminal Justice Adjustment Division. The exam that you take after a week-long study is 125 questions taken at the end of the class. The standard for certification is a score of 70%. Now, on top of the certification exam, they expect you to do a risk assessment system certification. It's called TRAS, short for Texas Risk Assessment System. The test here is a virtual test where you watch an actual TRAS assessment of an actual defendant. They score it, their experts score it, and the score usually is between 0 for the least violent or least chance of recidivism, which means least chance of reoffending, and to 35 to a high risk. It's rated between a 1 and a 4. 1 being the low risk. On top of the officer certification exam, you'll also be expected to pass an examination making you proficient in administering the Texas Risk Assessment System, short TRAS. Along with the certification exam, you require this on a performance-based test where you'll watch an actual video of a TRAS assessment being administered. You'll fill out your own scoring sheet individually. The scores range between 0 and 35. 0 being the least likely to reoffend, the lowest risk, and 35 being the highest risk. Once these numbers are accumulated, then you'll rate them on a 1, 2, 3, or 4. 1 being a high-risk individual, 4 being a low-risk individual. And it gives you a certain criterion-based assessment where you can find the best way to serve this person, help this person make it through probation and lead a productive life. Once you become a probation officer and fully certified, some judicial districts, like ours, allow their probation officers to carry a pistol while on duty. If your district allows you to do that, then you have to take TCOL certification. And what TCOL stands for is Texas Commission of Law Enforcement. It's the same certification that a police officer goes through, except the probation officers is not quite as stringent as the police officers. But what you do, you take a week-long class. I took mine in Fredericksburg. Really pretty environment, pretty town, and everything. But you take a test at the end of the class. Everything is going to be included with the test. But the fun thing about it was we shot about 1,000 rounds of ammunition that week because they want to make sure that everybody is proficient in their weapon and they're not dangerous to themselves or others, and they have accuracy and know how to disassemble and clean their gun and everything. So there's 2 tests you have to take for this. One being a written test, and it was not a very long test, about 50 questions, and then 2, you shoot at a target that looks like a human torso, but there's a target and it's about that big around. And if you can get every shot inside of that, you can shoot a perfect 250. You take it's 50 shots and they count 5 points each. Once you become a probation officer, there are several duties that you'll take care of. One of them is a pre-sentence investigation. Probation officers conduct these investigations to help decide appropriate punishment for someone who pleads guilty or is convicted of a crime. The officer interviews the offender and the offender's family members and work supervisors. A probation officer also interviews law enforcement officers that have had contact with the offender. This type of investigation helps determine if the offender uses drugs or abuses alcohol, has sufficient ties to the community, or lives in conditions that could impact his or her rehabilitation. Probation officers use the information gathered during this type of investigation to make sentencing recommendations. Another thing is casework. You'll be assigned a caseload. While at Rockwall, my caseload was about 185 people. Currently, it's about 120 or 130. We supervise those who've been sentenced to probation or paroled from jail. We also do a bond supervision where they haven't been indicted or they haven't been sentenced to probation or jail yet. The level of supervision depends on the offender's criminal history and the nature of his or her crime. Also, the TRAD assessment, like we talked about earlier. A violent offender is liable to receive more supervision than someone convicted of a misdemeanor. Bad check charge, for example, possession of marijuana, driving with a license invalid. Probation officers conduct regular meetings with offenders. We meet with offenders 1 time a month at least, unless there's a problem, when we can meet as many as once a week with people. They may also visit offenders at home. These are called field visits, and that we check for probation violations. During the home searches, probation officers look for firearms, weapons, drug paraphernalia. If an offender has been ordered to have no contact with children, the probation officers will also check the home for children's clothing, toys, baby food, diapers, and other signs that a child has visited. Now, these visits may seem invasive, but we're not going to go in and open up all the cabinets and search under the beds and, like you see on TV when people have a search warrant and come in and check, for criminal activity. The administrative work that's required for probation officers sometimes can be a little overwhelming because, like when I was a special ed teacher, I had to document. And that's one thing as a probation officer you need to know. If it is not written down and if there's not a note taken on it, then it didn't happen. These notes are called chronologies. Short, they call them chronos. Every meeting and every interaction you have with a probationer, you have to chrono and go over a synopsis or recap of the visit and what you talked about with the person. Supervising offenders involves a number of administrative tasks. In small probation departments that don't have someone to handle restitution payments, probation officers may have to accept payments, write payment receipts, and document payments in each offender's record. What restitution means is if I was to have a wreck and damage somebody's car or injure somebody, then I would have to be assessed a monetary payment to pay them back for their loss. If an offender has been sentenced to community service, participation during a drug or alcohol rehabilitation program, the probation officer must review reports from community service supervisors, counselors, and other professionals. Probation officers also may administer and insert on-site drug tests, urine analysis, or hair test, or nail test, or saliva test. It's not one of the more fun things to do. You have to actually witness the person urinating in order to do the test. Obviously, a male is going to witness a male, and females are going to witness the female. You also will have to extract the actual hair sample for the hair test. Now, the urine test can go back up to 30 days, 30 to 45 days to check for marijuana and other drugs. It depends on the rate of metabolism that a person's body has. A hair test can go back to almost 90 days. Nail test can go back almost 6 weeks. Legal requirements. Testifying in court gives probation officers an opportunity to present their pre-sentence investigation report to judges. If an offender is arrested on a probation violation, the probation officer also testifies at any hearings related to that matter. If a probation officer catches an offender in the act of violating probation, the officer may ask the judge to revoke the offender's probation or impose new conditions for the remainder of the probationary sentence. So if a person gets caught with a dirty drug test, or if they get arrested for another offense, those are two of the main things that a person can be violated on. And it's called a motion to revoke. And on a motion to revoke, you give the conditions that they have been found in non-compliance with. You relay that to the district attorney's office. The district attorney's office reads over it to make sure that they think it is a revocable offense and to formulate a plan possibly for more therapy or possibly for jail time even. And then when you get the signature back, then you forward it to the judge, and the judge will sign it, and he'll also sign a warrant for the person's arrest. The person turns themselves in, or the person gets arrested, and then the court process starts. Adult probation follows the statutes contained in Article 42A of the Texas Penal Code. Adult probation is a form of punishment for a crime, a diversionary program made of a part of a plea bargain. Probation may be granted to juvenile offenders, but the requirements of adult probation are typically far stricter and comprehensive. For adults, probation, the goal of the procedure is successfully creating a legal lifestyle that will prevent any crime in the future. There are many conditions under which probation may be granted. For adults, some may receive probation in lieu of jail time for a crime they've been convicted of committing. Others may be released from jail on probation after a certain amount of jail sentence has been served with no complications. Lawyers may also seek to have clients put on probation and serve a pretrial diversion or part of a plea bargain to avoid any trial at all. There are two classifications of crime. Misdemeanor charges. You have a Class C misdemeanor, which is something like a traffic ticket or a minor crime that doesn't usually require jail time. Then you have Class B and Class A. Class B being the middle one and Class A being the most severe misdemeanor charge. That's the ones you get probation on. The term misdemeanor refers to category criminal charges. Misdemeanor crimes are more serious than a citation. Like I said, a Class C is normally a citation. Anytime you get a traffic ticket, parking ticket, whatever, it is a Class C misdemeanor. A broad range of crimes are classified as misdemeanor criminal acts, ranging from assault and battery to property crimes. Laws regarding what crimes are considered to be misdemeanors vary from state to state. In some cases, felony charges may be reduced to misdemeanors. So if a person commits a felony, but then in court they decided that it wasn't quite as serious as what a felony would be called, they can agree to reduce it to a misdemeanor. Doesn't happen very often, but it does happen sometimes. Here are some examples. Crimes against a person. This includes charges like assault and battery, false imprisonment, or harassment. More serious injuries or injuries caused by the use of a weapon typically result in a felony charge. Crimes against property. Another example. Crimes against property generally involve some sort of theft, in this case shoplifting or larceny charges. The third one, crimes against public safety or public order. Some examples of this type misdemeanor crime include disorderly conduct, noise violations, open alcohol container violations, prostitution, and minor possessions of alcohol. The other classification of charges are felony charges. You have a state jail felony, which is the least stringent felony. Then you have a class 3, class 2, and a class 1 felony. Class 1 felony being the most serious. Their most serious type of criminal offense. Felonies often involve physical harm or threat of harm to victims, but they also include offenses like white-collar crime and fraud schemes. Offenses that otherwise are misdemeanors can be elevated to felonies for second-time offenders. So if you're a repeat assault and battery, it can be a felony the next time. Felony conviction, like a misdemeanor conviction, may not result in time behind bars, but felonies can carry potential imprisonment that ranges from time in prison, a year is often the low end, to life in prison without parole, or even death if it's something like murder. As with misdemeanors, states may also subdivide felonies by class or by degree. Felony example 1. Randy is convicted of a felony assault with a deadly weapon, even though the bottle he threw at another patron in a tavern missed its intended target. Even though he failed to injure the intended victim, his behavior was intended and did create the risk of serious physical injury. Felony example 2. Leora had 2 prior shoplifting convictions before being arrested for yet another shoplifting offense. State law allows prosecutors to charge shoplifting as a felony if the merchandise was worth a certain amount. The defendant has 2 or more shoplifting convictions. The prosecutor charges Leora with felony shoplifting. One of the most interesting examples that I had when I was at Rockwall was a person that had committed larceny and forgery. It was a misdemeanor. Well, when I was reviewing this person's criminal history, I found out that she had 16 aliases, 4 social security numbers, 4 driver's license. And it's probably one of my more interesting cases because she committed some more offenses in the Dallas area where she had given fake names to acquire loans. I got to talk to the FBI. I got to talk to the Secret Service. Also, because she had trouble with, she had embezzled several $1 million from FEMA. Even though she was charged with a misdemeanor for us and she did fulfill her probation agreement with us, I'm pretty sure right now that she is in a lot deeper trouble. There are a few different types of probation. You have straight probation, also known as adjudicated. You have a deferred adjudication. You also have a pretrial diversion. The type of probation called straight probation is found guilty when you're found guilty in court. Straight probation is offered to give defendants a second chance and the ability to develop a legal lifestyle. Since the defendant has already been found guilty, the jail sentence has already been determined in this case of the defendant not fulfilling the conditions of their probation. A criminal charge which you completed straight probation is not eligible for any type of record sealing. And we'll talk about record sealing in a minute. So in other words, it will always show on your criminal background check. Another type of probation is deferred adjudication. It's most commonly called as just deferred. Too often I hear people call this deferred adjudication. There's no F in adjudication. Same as above, deferred usually offered through a plea agreement with the state. Everything about deferred adjudication is the same as above except one major difference. In deferred adjudication, there is no jail sentence set. So if the defendant is unsuccessful with their probation, the judge can use the full range of punishment for the crime. The silver lining in the cloud of deferred adjudication is a non-disclosure. Once a deferred adjudication is successfully completed, you may request that the court seal your record. Having your record sealed, even partially, can greatly increase your private employment opportunities. Your record will only be able to be viewed by legal agencies. A third type of probation is called pretrial diversion. Texas criminal justice system offers pretrial diversion as a way for certain offenders to avoid prosecution as long as they meet eligibility rules and comply with conditions set by the court. It's a voluntary program with pros and cons. You need to know this before you opt in. There are some exceptions and flexibility related to the pretrial diversion program. But some of the rules are you must be a first-time offender, you cannot have a history involving previous pretrial diversion, the crime must be a misdemeanor, the offense can't be one related to family violence, anyone arrested for crimes of a sexual nature is not eligible unless the charge is prostitution. You cannot be a documented member of a gang. The pros for this, you avoid charges entirely as they're dropped once you complete the terms. Every entity that has your picture and your record has to delete this. You avoid prison and you continue work and conduct regular activities. Cons, you enter a guilty plea as a part of the arraignment. If you violate the terms of your pretrial diversion, the prosecution can resume in pursuing the case against you. One of the coolest pretrial diversion programs that I worked with is the North Texas Veterans Court. It's for veterans. But let me tell you, it's a 2-year program for these people, and it is an extremely difficult program. And it is very overwhelming in the beginning because they have to do several things and jump through several hoops to take care of this. But it's an awesome program on the other hand because it helps people avoid having a criminal record. It also helps people with other things like pretrial diversion because there are special programs that the veterans can go to that help with PTSD and other psychological things that they could have incurred while they were serving our country. 3G offenses are particularly serious and violent. The reason these crimes are listed in a special subsection of the Texas Code of Criminal Procedure was so that they could be punished more harshly. Specifically, 3G offenses are subject to certain sentencing enhancements involving probation and parole. What are the 3G felony offenses? The phrase 3G offense is used to refer to specific crimes that were once listed in Section 42.123G of the Texas Code of Criminal Procedure. 3G offenses, which are now listed in Article 42A.054 of the Texas Code of Criminal Procedures, include murder, capital murder, aggravated kidnapping, human trafficking, indecency with a child, sexual assault, aggravated sexual assault, injury to a child, elderly, disabled individual, it's a first-degree offense, aggravated robbery, burglary of a habitation, the compelling prostitution of a minor by force, threat, or fraud, criminal solicitation of a first-degree felony, sexual performance by a child, drug offenses involving the use of a child, and any felony which a deadly weapon was used before, during, and after the crime. The consequences of a 3G offense tend to be more severe than those of non-3G offenses. As a part of probation, I should have previously mentioned this, but you have a difference between deferred and straight probation. On deferred, the judge is reserving his judgment until the end of probation. On straight probation, you're giving a guilty plea and you will always be a convicted person, if it a misdemeanor or a felony. It's not uncommon for prosecutors and defense attorneys to negotiate plea agreements after you've been charged with a crime. In these negotiations, defense attorneys advocate for a reduction of penalties, including probation, in lieu of imprisonment in exchange for some sort of guilty plea. If you've been charged with a 3G offense in Texas, straight probation cannot be used as part of these plea negotiations. All plea bargains are negotiated and agreed upon by the prosecution and the defense, are subject to approval of a Texas judge. Texas law, however, prohibits judges from imposing straight probation as a punishment for a 3G offense. This does not mean that probation can never be imposed as punishment for a 3G offense. Juries still retain the right and the power to sentence a defendant as they see fit if a case goes to trial. You always have the opportunity to go to trial if you wish. Charges also can be reduced in a plea bargaining negotiation to remove 3G probation prohibition. Programs and classes that we use for conditions in probation. You have a substance abuse evaluation. It's usually the first thing that's done when you go to probation. It's where you do a system of questions and assessments, and sometimes it includes a urine analysis and see if you have a substance abuse problem. And it also helps the probation officer decide what treatment is best for the defendant. Some of the things that we might add in on the probation, we call it conditions of probation, is what you agreed to originally. And a lot of times these will include one of these: attending Alcohol Anonymous, Narcotics Anonymous, affectionately known as AA/NA. This is for obviously an alcohol or a drug offense. And a lot of times, 2 to 3 times a week, a person has to attend this. There's also a special program for a repeat offender that's called 90 and 90. That's where you have to go to 90 meetings in 90 days. That doesn't mean you have to go to one every day. You might go to 3 meetings a day, and it counts as 3 in the 90. For a drug offender, you have a DOE. It's called Drug Offender Education. And that's for anything from marijuana use all the way up to, possession of a controlled substance or possession of a dangerous drug. Then you have DWI education. That's for the DWI first offense. It's a 15-hour class. It lasts for 5 days, and a person learns the impact of a DWI, because the person that commits the DWI is not the only one that's affected. Sometimes other people are affected. Then you have a repeat DWI offender program called DWI Intervention, also known as DWII. This is for the second or more offenses. Now, just a little side note, that once a person receives their third DWI, every one there and after count as a felony. Usually the first DWI is a Class B misdemeanor, unless it involves a child being in the car with you, or an accident. And if you have an accident with your DWI, it also could be called assault with a deadly weapon, because a car is considered a deadly weapon in a DWI. Along with the other DWI things that could be included in your conditions of probation, you have the Victim Impact Panel. Victim Impact Panel is about a 2.5-hour program that is used by the Mothers Against Drunk Driving. If you want to see some details about it, you can go to madd.org. That's Mothers Against Drunk Driving. It takes about 2.5 hours. In Dallas, they used to go to them when I was at Rockwall, and it would last about 2.5 or 3 hours. You see some videos, they would talk, and then they would give you a certificate. For people who need a little extra help, you have Supportive Outpatient Program, known as SOP, is what we call it. That's the abbreviation. There's a lot of abbreviations that you use in probation. In the Supportive Outpatient Program, you go to 12 to 15 meetings over a 12 to 15 week period, and it's supposed to give you the skills to kick the habit of, drug use or excessive alcohol use, any abuse of a substance. It also has a little therapeutic effect in it too, where you can be counseled. And if SOP is not considered strong enough for the defendant, then IOP can be administered. That is intensive outpatient. The intensive outpatient program is a lot longer, and as the first initial stands for, is a lot more intensive. The person goes to 2 to 3 meetings for the first week in phase 1, and then when they graduate to phase 2, then it's 2 meetings a week, and then when the counselor decides that that's fine, then they'll go to 1 meeting a week, and it usually lasts 24 to 36 weeks. Another thing for violent offenders, anger management. If a person has a problem with anger, then they go to anger management. It's not like the movie either. It's not all funny and everything. But what this is supposed to get inside the person's head and help them find ways to cope with their anger that help them relieve the stress that creates the want for them to act out. Now, if a person has been involved in a family violence incident, then Batter's Intervention, called BIP, B-I-P-P, Batter's Intervention Prevention Program is what that's the acronym for. And what this does is, again, teaches a person to find ways to deflect their anger where they won't act out against one of their loved ones. Now, in some of the stronger cases, the sex offender cases, you have a sex offender counseling program. And the sex offender counseling program is a pretty long and pretty intensive program that involves a lot of tests and strong counseling. And also, once a year, a sex offender has to have a polygraph test, and where they'll ask a series of questions. And if the sex offender doesn't comply with this, then it could be considered a violation of their probation, and the sex offender can be revoked, have a motion to revoke, MTR filed, and go through court again. And the judge will either decide to put them in jail or decide to put them, back on probation with some stronger conditions. It's a pretty serious thing. And, on a side note, with the sex offenders, they're not allowed to be on, many of them are not allowed to be on the internet, especially if it was an internet-based crime. They lose a lot of privacy. They have to register, and you can find the registered sex offender list on the internet. And even I went as far as applying conditions where they have to pay $35 a month, and there is a program that goes on their laptop or on their phone or both, and it takes a screenshot of the computer every 15 seconds. It also scans any text message or anything you typed into your computer for any suggestive type language or verbiage, and it sends alerts to a central office, and then we investigate what the person's been looking. Usually, a sex offender is only allowed to get on the internet at a place where there's a serious firewall, like a library or like the probation office. So be very wary if you go to the library and a person is on a computer there. Not saying that everybody goes there as a sex offender, but that's where some of the people have to go. On top of all these programs, we have licensed counselors, and a person can go through individual counseling. And individual counseling is a great thing. It gives you the tools to become a legal person that doesn't partake in criminal activity. You have two types of activities. You have pro-social activities. And what pro-social activities mean in probation means an activity that's within the law. And an antisocial activity is an activity that is against the law. And individual counseling helps you deal with some of the urges that you have to repeat. And the last one I'm going to talk about as far as this goes is shock therapy. Now, I'm not talking about electrical shock therapy where somebody puts an extension cord on you and tries to electrocute you. But what shock therapy is this jail sanction. And that's where when a person, as part of their probation, it's considered a shock for them to have to go into jail. It may be for 5 days. It may be for 30 days. I've had probationers that I've done intakes on, and I did the intake on them while they were in custody wearing the orange shirt. And part of their conditions were that they had to go into jail for 30 days. So I give them my contact information, go over all their conditions of probation, and then they go to jail. And eventually I'll see them 30 days later, because as soon as they get out of jail, they come see me. And then we set up our weekly appointments, monthly appointments, or whatever appointments that I see fit. Along with probation, sometimes you're sentenced on your conditions to have to acquire monitoring devices. These are out of your own pocket, and some of these are pretty expensive. One of the most common ones that people get is called an IID, which is short for ignition interlock device. You hear so many stories about people who say, man, I have one of those interlocks, and what I do, I get somebody else to blow in it for me, and then I can start my car drunk and just go wherever I want to. Well, technology has kind of caught up with the people who tried to cheat in the system. Now, 99.9% of all interlock devices are required to have a photo monitoring device, and where it takes a picture of you while you're trying to blow into the device. And I have seen everything. I have seen somebody try to dress up like another person and blow into the interlock device for them. I've seen a baby in the seat. I've seen the person's wife in the seat trying to blow into it. And there's always an excuse. But, you can't fool the system. occasionally you can fool the system and get away with it, but in most cases, it'll end up catching up to you. If a person is convicted of a DWI, then more than likely they're going to get an ignition interlock device, especially on the second one. On the second one, it's almost mandatory that you're going to get that. Another one, if a person has gotten a DWI or an alcohol-related offense that they're put on probation for, and they don't drive, say they don't drive, then they have an in-home alcohol monitor. It's called in-home system. And it's kind of confusing to me because it's spelled INHOM, alcohol monitor, and that's where they have testing windows set. A standard testing window would be in the morning from 5 a.m. to 8 a.m. You have to blow a clean alcohol monitor at that time, and it has to have 0.00 alcohol in your system. Now, some of the things that can skew these are mouthwash, cologne, perfume, and so that's why it's recommended that a person that has an ignition interlock device or an in-home alcohol monitor get non-alcoholic mouthwash. Now, usually on the in-home monitor, it's a morning, it's middle of the day, it's afternoon, and it's at night before bed. The alcohol can stay in your system where you'll blow positive a high BAC, which BAC stands for blood alcohol content, for up to 8 hours. And the ways you can tell if it's something has been introduced into the system like mouthwash is if say a person blows a 0.35, 0.035 would be pretty much pickled, but 0.035, and then they blow again in 5 minutes, and it's 0.033, and they blow in another 5 minutes, and it's 0.025. It's gradually going down, so that means that there was alcohol consumed. Or if a person has just had mouthwash in their system and didn't rinse their mouth out, and it has an alcohol base like Listerine, and they blow 0.035, and then 5 minutes later they blow and it's 0.00, then that means that there was a contaminant in the system. Another monitoring system, you hear about these on TV and may see them in public and everything, is called the SCRAM. Now, SCRAM is a Secure Continuous Remote Alcohol Monitoring System. That's what SCRAM stands for. It's an ankle bracelet. It is 24 hours, 7 days a week alcohol monitoring. And it's pretty high tech. It also has a GPS monitor on it so you can tell where the person's at. On the SCRAM system, there's been a lot of ways trying to fool these. They try to put their sock in between this and their ankle. And if you get caught trying to tamper with your SCRAM device, it is a violation, and you can and most likely will be revoked for this, or even have more conditions put on your probation. Another interesting way, I had one of my veterans over in Rockwall put lunch meat in between the SCRAM monitor and his ankle. Bologna is what he put in between there. And eventually we found out about it, and eventually he had to serve a jail sanction. Another thing is a GPS monitor, just a straight GPS monitor, an ankle bracelet, and they set parameters. If say that a person has been abusive to somebody and they want to keep them away, have a stay away order or a protective order, then they can put a 150-foot radius around this person's home and this person's work. And anytime this person enters that zone, an alert is sent to law enforcement, sent to the district attorney's office, and sent to the probation officer. And we can act on it real quickly because, one of our main things is to protect the victims. Protect the victims from person reoffending. It can be very serious. Another one is a drug patch. It's just a little sticky patch that goes on your arm, like right here, on your arm, and it works on the sweat glands. And if a person, does cocaine, heroin, methamphetamines, Xanax, anything, it gets into your sweat glands. And when the patch is taken off on a weekly basis, they can test it, and if it comes back positive, then there'll be a hair test done, or there'll be a urine analysis done, and to check what drugs the person has put into their system. And the last one, the monitoring that we use is a random UA. A lot of times a drug offender will be UA'd every month, or sometimes be called in the middle of the month for a random urine analysis. And if they haven't been called in for a random urine analysis in a little while, and you get a report of possible drug use, or you suspect possible drug use, you use a hair test. And like I said earlier, the hair test can go back up to 90 days on some drugs. The urine analysis can go back to 30 to 45 days. The hair test is pretty severe, and it will detect things. And if you ever were to get on probation, please do not try to circumvent these, because I've had people on urinalysis, they've used prosthetic parts of their body or inserted things that contain clean urine, and they've gotten caught. And that's a class A misdemeanor right there in itself. Plus, it will violate you for your probation, because it's a new offense, and you'll do jail time possibly, or go into the next facilities that we're going to talk about, or the next parts of probation we're going to talk about that's a little more strict. If a person just can't seem to kick the habit, and a person is still using drugs and has had dirty UAs, or has positive blows on their interlock device, or their in-home device, or their scram monitor, the drug patch, we use a thing called intermediate sanction facility. And if you've ever been around anybody that's on probation, find out they've been sent to ISF. It's part of the Texas Criminal Justice Division. Intermediate sanction facility is an in-custody treatment alternative for medium to high-risk felony offenders who are facing probation or parole revocations. The legislature authorized the implementation of ISF in Texas to alleviate the overcrowding of prisons. These short-term treatment facilities are designed to help offenders address the underlying reasons they commit crime and provide alternative to prison when a probationer or parolee is facing a revocation. There are 3 tracks for this. You have the abuse treatment track. The program is designed to help the offender deal with substance abuse issues that they can avoid all the potential complications that arise from them, especially those that relate to the offender ending up back in jail or prison. This program takes 90 days to complete, 3 months basically. You have the substance abuse relapse track. And this program is designed to help the offenders who have previously received some sort of substance abuse program, but have since relapsed into using again. This program takes 45 days to complete. The relapse track requires the offender to have previously completed a substance abuse program, specifically SAFE, Substance Abuse Felony Punishment Facility, other therapeutic community treatment programs, or have a history of residential treatment. Then you have the cognitive track. And if you know anything about what cognitive means, it's about thinking. It's progress designed to help the offenders deal with a mental or emotional issue, as well as building life skills. This program takes 90 days to complete. The judge can order a 30-day extension in some circumstances, meaning the maximum time a person can spend in ISF is 120 days. Additionally, once a person is released from ISF, they're generally required to complete an aftercare program. And the aftercare program will include things like the drug offender education, DOA, or supportive outpatient, or a monitoring device, or a combination of such. Now, the more stricter one and the longer one is called SAFE-P, SAFPF. It's also called SAFE-P. It stands for Substance Abuse Felony Placement Facility. It's a treatment program that's run by the rehabilitation programs of the Texas Department of Criminal Justice, TDCJ. This is a program that the government has designed to give drug abuse treatment inside and later outside Texas prisons. The program is supposed to provide different treatment options for the needs of individuals suffering from substance abuse addiction. Overall, the idea is that by giving people treatment, Texas will not have the same people committing crimes over and over and over again. That's called recidivism. That's when a person commits a crime over and over and over. Recidivism is a word you hear a lot in probation. The program is only available for felony charges. If you're considering a plea bargain that includes going to say fee, then you'll need to speak with a criminal defense attorney for a complete understanding of the program. All right, probation in a nutshell. This is everything to do with probation in just a brief description of it. Probation is a tempting proposition for people when they're charged with a crime. One, you avoid jail and go on probation, deferred adjudication, but is it really that good of a deal? Yes, I think it is. Why it may be good. Here are reasons that it may be good. The obvious first, you don't have to go to jail if you abide by all the conditions of your probation set forth in your court case. Deferred adjudication. You can continue leading a fairly normal life as long as you abide by the conditions. It's great for people that want to continue to work or go to school. If it's deferred adjudication, another reason it may be good for you, so as long as you complete it successfully, you will not have a conviction on your record. The straight probation, you're already pleading guilty and you're already being sentenced and you are adjudicated and you will be convicted. And things like DWI, they're going to be a conviction. If you get a DWI, they are definitely going to convict you. That's part of the Texas thing, that you are going to be convicted as the result of a DWI. Additionally, if you complete a deferred adjudication, you may get the records related to the offense sealed through an order of non-disclosure. However, it only prevents disclosure from public inquiries. As previously said, law enforcement and state licensing agencies, state of nursing bar of Texas teachers, pretty much any licensing authority can see these. Why might it be a bad deal? You think about this. It could be a bad deal. I've had to file several motion to revokes, hundreds of motion to revokes in my little brief 3-year career as a probation officer, 2.5 years. It's just people don't want to do what they've already agreed to, because you're signing a contract when you're getting probation, and there are conditions that you sign your name on. So if you ever get faced in a situation like this, make sure you read everything. Make sure you understand everything before you agree to probation, because it can be just literally horrible for people that don't want to follow rules. It can be a tightrope walk. You may be facing a lot of conditions ranging from fines, fees, ignition interlocks, home alcohol monitoring device, and paying for their associated maintenance, calibration fees, community service, court-ordered classes. The list goes on and on. If you fail to do any of these things, any one by themselves can be enough to revoke your probation, sentence, go to jail. And there are other things. You also have to pay a fine. You might have to pay a $500 to $1,000 fine. If you have a court-appointed attorney, you might have to pay $300 to $600 on that. You'll have a court fee. A typical DWI felony court fee is $412.10. $200 is about as low as a court fee goes. So there's a lot of costs that involve this. Community supervision, probation, costs $60 a month in itself. So if a person gets put on 1-year probation or driving with a license invalid with a previous conviction, it's going to be $720 of probation. Now, it's allowed to be paid out month to month, just like the fines and the court fees. They're allowed to be paid out month to month. But still, that's a lot of money. If a person gets put on 2 years of probation, $1,440, $60 a month. And here's what everybody needs to know before they accept probation. Not all offenses qualify for non-disclosure. That means although you don't have a conviction on your record, all other information relating to the arrest charges, disposition, are on your record forever. For example, assault, family violence cannot be sealed by an order of non-disclosure. Now, on a side note on that, if a person is charged with family violence and the person that they have committed the violent act against decides they don't want to prosecute, that doesn't mean it's going to go away. If it's something that's severe enough that the state wants to pick it up, the state can pick up the charges, and then they will pursue it. So the person just can't get off scot-free by forcing the person that he committed the violent act against to not prosecute. The ugly. Here's the good, the bad, and the ugly. If you mess up, you could end up doing more time than you took a jail prison sentence up front. If it's straight probation, like a DWI, then you can be sentenced to the length of the probationary term. If it's deferred adjudication, however, you could be sentenced to the full range of punishment for the offense. For example, if you're on deferred adjudication for the possession of 1 to 4 grams of cocaine for a period of 3 years, you violate, you could be sentenced up to 10 years. This is because the range of punishment for that amount of cocaine is up to 10 years in the TDC, Texas Department of Corrections, Prison, Huntsville. People are generally overly optimistic of their chances to complete probation. It's a lot to deal with, and you need to be honest and upfront with your probation officer. You certainly might be able to make a paradigm shift in your life. Even though you have a rap sheet a mile long, you need to be realistic. The takeaway: consider your options carefully and discuss all consequences of your plea of guilty and imposition of suspended sentence with your attorney. There might be other options available that fit your situation. Probation to me has been a very rewarding job so far. And if you have any interest in it, I would recommend you going into it. It has great benefits. I mean, you have an awesome retirement. You have awesome insurance. It's free. You don't have to pay for your insurance. Um, you get a chance to help people. You get a chance to make a difference in people's lives. Maybe not just the person that you have on probation, maybe their family's lives. But the downside of it, as I've ran into lately, there's a lot of people that I've known for a long time that have had problems in their life and they have not wanted to change. Because if you want to change, if you want to make a difference in your life, one of the most important things is to look in the mirror. Because the person in the mirror is the only person that's going to be able to make a difference. It hurts my feelings so bad when I see somebody that I've known for most of my life or for a major portion of my life that just cannot make a change and just keep making the same mistakes over and over and over. But, I have a legal responsibility and I have to turn this over to the district attorney's office and the judge, and then they have to make the alternative decision. I hope this has been informative to you, and I hope it's helped you. And one thing, crossing my fingers, I'm hoping that I don't have to see you guys on the other side of the desk. Live a good life, do what you're supposed to do, and slap me a high five when you see me in public. Anyway, take care.